Judicial Assistant should have given each of you a copy of the revised instructions, and I want to go through those again. First of all, I would propose giving 100 opening instructions. I'll note that on the next page, I've inserted 602. I indicated that that's where I thought it was most appropriate to insert 602, so I'll give 100 followed by 602. Then I'll give 103, evidence defined. 115, one defendant, 3 counts. Changes that have been outlined in there, we've talked about. It'll say the counts will be listed as Tuesday, February 22nd, and I've revised the initials used for Mr. Therian. It will say Shad Therian. I've made the agreed upon elections on the 1193, mutilating a corpse, and then of course we move into 1218A, and I have inserted the language that was requested by the state. Mr. Froelich, I believe, objected to that. I ruled, however, that I was going to give it, and that sentence is, of course, under the subheading meaning of did not consent. It's the very last sentence, and I added that in. Then I'll give the modified 755A that was agreed upon and designed by Mr. Saunders. I will give 140, burden of proof and presumption of innocence. 145, information not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 150, stricken testimony. 155, exhibits. 157, remarks of counsel. 160, closing arguments of counsel. I'll give 170, circumstantial evidence. I'll give 172, circumstantial evidence, flight, escape, concealment. I will give 180, statements of defendant. 190, weight of evidence. 195, juror's knowledge. 200, expert testimony general. I'll give 255, state need not prove exact date of commission. I'll give 300, credibility of witnesses. I'll give 460, closing instruction. 484, verdict submitted for 1 defendant, 3 counts, separate verdict on each count. I'll give 515, unanimous verdict and selection of presiding juror. We'll then select the alternates. A couple of things I want to take up. First of all, I did want to, because we didn't bring this up at our instruction conference, but it's not too big of a problem. I asked my clerk if she could hand one of those to each of the attorneys. This is what Mr. Froelich and I had spoken about earlier, 315. And Mr. Froelich, I know you didn't have a copy of that, but you can have a brief moment to review that with your client and take a few minutes to talk with her about whether or not you and she would like me to give that.
Okay, Your Honor. Thank you. Your Honor, I have reviewed instruction 315. I'm fine with that. And I showed it to my client.
Okay, and I appreciate that, Mr. Froelich. I think I need more than just I'm fine with that. This has got to be something that you either ask me to give or ask me not to give. And I'm going to have a colloquy with your client about it. Do you need some time to speak with her about it? Because if you do, I can leave the bench and come back in a few minutes.
Yeah, maybe that would be a good idea, Your Honor.
All right. We'll take about 5 minutes and have a conversation with her, Mr. Froelich.
Thank you.
Okay, so Mr. Froelich, I want to direct my attention to you. Have you had an opportunity to speak with your client about 315?
Yes, so I just want to put this on the record. I talked to my client, we've talked a number of times throughout the duration of my representation. I've advised her that if the case went to a jury trial, she has a right to testify, she has a right to take the witness stand, she has a right to testify in her own defense, but anything that is said could possibly be used against her. So she understands that she has a constitutional right to testify. I also told her that she has an absolute constitutional right not to testify. She has a right to remain silent. She can invoke her Fifth Amendment privileges against self-incrimination. And we've talked about this at length on numerous occasions, several times today. We've reviewed this jury instruction 315, and she's indicated to me that she wishes to exercise her right to remain silent. Before, when you asked the question, I wasn't quite sure what you were asking, but I agree to the court reading instruction 315 to the jury. Thank you.
So you're asking that I read this instruction to the jury?
Yes.
Okay. Ms. Schabusiness, you have a right to have this instruction read, or you have a right not to have the instruction read. And that right belongs to you and to you alone. Do you understand that?
Yes, I do.
Okay. Your attorney indicates to me that he would like me to have this instruction read to the jury. Is that correct?
Yes.
And you agree with that?
Yes.
You feel you need any more time to talk to him about that decision?
No.
Okay. I'm satisfied. Well, first of all, Mr. Saunders, any further inquiry you'd like me to make regarding 315?
No.
Mr. Froelich?
No, Your Honor, thank you.
I'm satisfied that Ms. Schabusiness has indicated that she would like me to read 315 to the jury, and as a result of that, I'm going to do that. The only other topic I want to take up with the attorneys, and then of course I'll ask generally whether you have anything you want to raise with me. Oftentimes I get a request, I usually read these in order, oftentimes I get a request to have 160 closing arguments read just before you give the closing arguments, which would mean it's right after 315. Before closings, and then obviously after closings I read 460. Any objection to my reading 160 just before closings, Mr. Saunders?
No.
Mr. Froelich?
No, Your Honor.
Okay, I'm going to have 160 then. I'll slide that in just before 315. Strike that, just after 315. Okay. Mr. Saunders, are there any other topics or issues regarding the instructions that you'd like to bring up with me?
No.
You're satisfied with the instructions and the order in which I propose to give them?
Yes.
Mr. Froelich, any topics you'd like to raise regarding the instructions?
No, I would not, Your Honor. I'm in agreement with the form of the instructions.
And the order with which I propose to give them?
Yes, I am.
Very good. Then, before I ask you about durations of closings, I guess what I would just indicate is I intend to bring the jury out. I intend to instruct them right up through the closing instruction. Attorneys can close. There will be potentially some rebuttal closing. And then we'll select the alternate and the deliberations will be underway. Anything to bring up before we do that, Mr. Saunders?
No.
Mr. Froelich?
No, Your Honor.
Okay. Then with that, we'll bring the jury in. Okay, be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. In this first phase of the trial, you have heard evidence that dealt solely with the defendant's conduct during the alleged incident. You are to determine only whether the defendant is guilty of the charges of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. If you find the defendant not guilty, the trial will be over. If you find the defendant guilty, the trial will proceed to the second phase, where you will determine whether the defendant was not responsible by reason of mental disease or defect. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The first count of the information in this case charges that, count 1, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did cause the death of Shad Therian with the intent to kill that person, contrary to sections 940.01 sub 1 sub A, 939.62 sub 1 sub C Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, the defendant caused the death of Shad Therian. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill Shad Therian. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Shad Therian with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count of the information charges that count 2, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to section 940.11 sub 1 and 939.62 sub 1 sub c of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, that the defendant dismembered a corpse. Second, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information charges that, count 3, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did have sexual intercourse with Shad Therian without that person's consent, contrary to sections 940.225 sub 3 sub a and 939.62 sub 1 sub b of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense be charged beyond a reasonable doubt. Third-degree sexual assault, as defined in section 940.225 sub 3 sub a of the Criminal Code of Wisconsin, is committed by one who has sexual intercourse with another person without consent. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, that the defendant had sexual intercourse with Shad Therian. Second, that Shad Therian did not consent to the sexual intercourse. Sexual intercourse means any intrusion, however slight, of any part of a person's body or of any object into the genitalia or anal opening of another. Emission of semen is not required. Did not consent means that Shad Therian did not freely agree to have sexual intercourse with the defendant. In deciding whether Shad Therian did not consent, you should consider what the defendant said and did, along with all the other facts and circumstances. This element does not require that Shad Therian offered physical resistance. It is immaterial whether Shad Therian is dead or alive at the time of the sexual intercourse. If you are satisfied beyond a reasonable doubt that both elements of third-degree sexual assault have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. An intoxicated or drugged condition is a defense to criminal liability only if it is involuntarily produced. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing the testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remark suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was actually restated here at trial. And whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all of the other evidence in determining how much weight, if any, the statement deserves. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than the testimony of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. If you find that the offense charged was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the alleged date, that is sufficient. It is the duty of the jury to scrutinize and to weigh the testimony of each witness and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then, give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and under the instructions given to you by the court. We're now ready for the attorneys to give their closing arguments. I want to speak briefly, however, to both the attorneys that are giving the closing arguments, if you could approach. And ladies and gentlemen, in the event you were wondering, you are going to get a copy of these instructions during your deliberations, because I know they're lengthy. Having said that, Mr. Saunders, are you prepared to give a closing argument?
Yes, Your Honor.
Very good. Go ahead.
Good afternoon. I want to start with something that we heard yesterday, or actually Monday, during opening statements. Counsel told us that there's always two sides to every story, and with all due respect, this is not one of those stories. This is a story that pretty clearly shows what happened. It's a story of the defendant taking a dog collar that was around her friend's neck and pulling it so hard and for so long and with such force that it caused his death. That in that moment, she made a deliberate choice to end her friend's life. She then, after the fact, degrades his body, engages in sexual acts with him. This is a story of the defendant then dismembering him and leaving his remains all over the house for his mother to find. And this isn't the state's story. This isn't law enforcement's story. It's the defendant's story, as you heard today, right? So as we go through this, it's easy to sit here and say, yes, the defendant confessed, and it's true. She confessed to every single element that you will see that the state needs to prove. But we didn't just stop there, right? We could have been done with this case on Monday, played her interview, and called it a day. But you should expect more, right? We have the burden of proof, and obviously we called a number of witnesses to establish what this story shows. So I want to walk through that story. And I know there's a lot of law that was just read to you, but I'm a visual learner, so I like to see kind of what we're looking at here. So as I go through these 3 offenses, there's really, as you'll see, 6 things the state needs to prove beyond a reasonable doubt. Not every fact that was testified to, not what time somebody got to Scott Holmes' house at the end of the night. The 6 elements are what the state needs to prove to you beyond a reasonable doubt, okay? So first, count 1, first-degree intentional homicide. First, that the defendant caused the death of Shad, and that she, second, acted with intent to kill him, okay? And again, as I already mentioned, as we go through these elements, you heard earlier this morning that the defendant is acknowledging every element that we hear, okay? Independent of the information you heard today, with the investigation you heard, the DNA, the other information, Dr. Tranquita's testimony, I would argue would prove all these elements as well. But you have on top of that the defendant's admissions to all these elements. Okay? So the defendant caused the death of Shad. I mean, that should be fairly clear here. Obviously, she admits that. You heard Dr. Tranquita's testimony of how Shad died, the cause and the manner of death, strangulation, excessive force being placed on the neck, producing his death. That was the sole cause of death that we heard. So let's talk about intent, right? Because that admittedly sometimes is a tricky topic, right? We can never know anyone's intent truly, and as you're told, you're not going into the mind of somebody, right? Kind of looking at all the facts and circumstances that you see. In this case, you have the benefit of the defendant opening up her mind to you and telling you what her intent was here. But you also have other signs, right? So what does intent mean? That somebody had the mental purpose to do something, right? Some volition. Or that they're aware that what they're doing is practically certain to cause that result, right? And you heard both, really, from the defendant. So I want to walk through that because there's a lot of points in that interview where the defendant is telling you exactly what her intent was in this case, right? His face was turning purple, right? She describes that and how he's coughing up blood, and you know that's accurate, right? Because you heard Dr. Tranquita's testimony and you saw those photographs. She's seeing that in person, and yet what does she say? I still didn't stop. No. She felt a heartbeat at one point, right? She talks about feeling his heartbeat, and she kept pulling more, and he wouldn't die. And, I just wanted him, and I was like, damn. Right? She admits even that Shad's struggling in this moment, that he's fighting back, right? You heard from Dr. Tranquita as well about how it looked like at one point there were signs of that, where the collar slipped up along the tongue. She's telling you, I was waiting for him to die. I liked it. She figured I'm already this far, and she's pantomiming the act. It's like she's starting a lawnmower. That's how hard she's pulling on this chain, right? Took 3 to 5 minutes, she thinks. And again, that's consistent with Dr. Tranquita, right? This is not an accident. This isn't a whoops. This is an intentional act, right? I don't need to prove that she went to that house with this intent, right? We talked about that in voir dire, and we kind of talked through that concept of how, as you're instructed, intent can be formed in the instant before an act, the instant before the pull of a trigger, the instant in this case before Ms. Schabusiness decides, I'm going to go further and pull on this chain so hard that it causes the result that we saw in Shad, right? So we have the mental purpose, right, from the defendant's own mouth, and that's consistent with everything else we're seeing in the case. But you also have Detective Kempf asking her, I mean, in that moment, did you kind of realize if you kept pulling on that chain that he would die? She's like, probably, yeah. Yeah, she was aware of that. Right, so that goes to this kind of the second either-or part of intent, right? Was aware that her conduct was practically certain to cause that result, and it's probably obvious as you sit here of what's going to happen when you're pulling a metal chain like that hard for that long, seeing the result of what's happening to another person, that is going to be the result, right? So you're told you can't look into a person's mind. The defendant told you exactly what her intent was in this case. But as I mentioned, you also have other indicators, right? You have Dr. Tranquita's testimony describing the amount of force that would need to have been done to cause the injuries that he's observing, right? Down to the inner neck muscles, and he was talking about how strong and thick those neck muscles are, and there was hemorrhaging that deep. That's how hard and how long and how much injury the defendant was causing, right? This isn't an accident. If it's an accident, you're not going forward. You're not seeing this result and keep pulling. You're calling for help. You're stopping. You're certainly not after the fact, after you finally finish, then cutting up his body, right? You have all the evidence in this case points to intent, right? You have her acts after the fact, like I said. You know, if this was an accident, something happens, right? You call for help, and you have the exact opposite. You have the defendant cutting him up and cleaning up, getting rid of the remains, pouring it down the shower. We heard a lot of testimony about that. Kind of wiping up with the Clorox wipes, which the defendant is acknowledging as well. So you have the defendant's statement in the case, and it lines up with everything else in the case, right? Even little facts that she's remembering and telling you about, right? The timeline of the February 21st night, right? We heard from A.J. Gannon, you heard the stipulated testimony from Mr. Tomes, you heard from Mike Therian. It's all consistent. Yeah, they were coming and going. You then heard from Steve Hendricks about, yep, they got back sometime in the early morning and I let them in. Defendant's telling you that same thing. Steve is talking about how at one point during the day on the 22nd, she comes up and asks for her eyeglasses, and we heard the defendant talk about that as well. We heard Detective Graff testify about that. So everything she's saying is consistent with what we're objectively seeing, what law enforcement is finding. And in some respects, the defendant's leading the investigation, right? Because when they get there, when law enforcement gets there, we saw Officer Wanish's body cam. We heard from Detective Scanlon and even Dr. Tranquita about how it was really hard to determine what exactly happened when they first got there. And all that information is being provided by the defendant. Okay? So it's an intentional act. She had the mental purpose. We heard about that. It's not, as I talked about, it can be formed at any time before the act, right? It doesn't need to be premeditated. That's not the law in this state. And it's really important, too, to not confuse this with motive, right? We heard evidence about motive, right, and her interest in Jeffrey Dahmer and all that entails. But intent doesn't mean motive. This is what intent means, and we proved intent, right? She caused his death, and she acted intentionally, and she told you as much. So those are the two elements. Those are the two things the state needs to prove beyond a reasonable doubt. Count two, mutilating a corpse. So again, there's two elements for this crime. First, the defendant dismembered a corpse. Second, did so with the intent to conceal a crime. So the first element, I think, is pretty clear, right? And we heard extensive testimony from many people, and we saw Dr. Tranquita's diagrams, and obviously I can't imagine this element is going to be in dispute, right? And so again, though, we have this concept of intent, the purpose to conceal a crime, right? And I mean, as you're instructed, you use your common sense. Like, why is somebody going to this length, not only cutting up a body? We heard from Dr. Tranquita about the multiple sort of start and stop kind of signs, the total evisceration of Shad, bagging him into other bags and attempting to carry out. Like, that's the intent, right? We use our common sense that that's why you're doing that. But again, she was asked about this, the defendant. And remember in that February 28th interview, the second interview with Detective Graff and Detective Scanlon, she's saying exactly what her intent was, right? It was because there's other people in the house. Like, what am I going to do? Leave the body and have mom find it? She admits, again, this was her intent, and it's obvious with our common sense, but it shows that the state has proved both elements of this crime as well. Okay. Count 3, it's third-degree sexual assault. So if the defendant had sexual intercourse with Shad and did so without consent. So let's talk about the first part. Sexual intercourse is defined in this state as inserting any object into the genital or anal opening of another, or engaging in oral contact with the penis. We heard about both, right? The defendant admitted to both. She's talking about how she's put the dildo in Chad's anus after she killed him. She's talking about how she was sucking on his penis, and there were other phrases used to that effect. So again, we have, for both elements here, the defendant's admissions. And we heard from Mr. Scott, didn't we? We heard from Mr. Scott about the DNA testing that was done, right? And for some of the reasons why, even though the defendant's DNA is on that dildo in Shad's house, Shad's DNA wasn't found on there. And nothing excludes that possibility. And again, everything the defendant's telling you is consistent with other things you're seeing. So there's no reason to believe, a reasonable hypothesis to believe, that she's not also telling you what's happened in this case too, right, for this count. And the second element, did not consent. I mean, that, as you're instructed, is kind of inferred by the fact that at the time that the defendant's telling you she's engaging in these acts, that Shad's deceased, right? So he's not in a position to consent, okay? So those are the two elements for count 3. So in total, 6 elements for the 3 offenses. And again, you're given a lot of law on how to assess credibility of witnesses, and that's good, and you should follow it. Really, you kind of just use your common sense as jurors. And again, the defendant's telling you what happened, and there's nothing in the case to disbelieve what she's saying, right? So you have the defendant's admissions, as I mentioned earlier. There's other evidence that kind of just only should bolster the conviction in the defendant's guilt, right? We heard from Kevin Scott, who heard or testified about the DNA testing he did. Shad's blood on the defendant's hands, on her clothing, on the sweatpants, about how the knives that were found that had Shad's blood on them, right? Even absent her confession, I mean, there's ample evidence here to convict on all 3 counts. You have many witnesses coming in to talk about the integrity of the investigation, how law enforcement didn't just take the confession and go home, right? We do more, right? Send things in for DNA. We speak with other witnesses. We corroborate the defendant's timeline of things. You heard all that. And that's really important, right? We have the burden of proof, and we talked about that, and we embrace that burden of proof. You should hold us to that standard as the state to prove something beyond a reasonable doubt. And that's why we call people from Madison to come up to talk for 5 minutes about, yeah, I received this piece of evidence, and it was fine. And I returned that piece of evidence, and it was fine. Right? Because it's important. We want to show that law enforcement did a thorough investigation in this case. And they did. Because we have the burden of proof. You're instructed on what the burden of proof is and what it's not, right? It's a reasonable doubt, a reasonable hypothesis consistent with guilt, consistent with innocence. You should find the defendant not guilty. But you're not searching for doubt. You're ultimately searching for the truth. So even if it's a heavy burden, it doesn't mean the decision is difficult in cases. You are instructed not to search for doubt. You're to search for the truth. And there's not a reasonable hypothesis in this case consistent with the defendant's innocence. There just isn't, right? There's one truth in this case. There's one side of the story, and it happens to be the defendant's story as well, but it's consistent with everyone else's story. It's because that story is the truth of what the defendant did to her friend Shad. And based on that, we would ask that you return guilty verdicts on all 3 counts. Thank you.
Mr. Froelich, are you ready to make your closing argument?
Yes, I am, Your Honor. Thank you. Gentlemen, may it please the court, ladies and gentlemen of the jury, Mr. Lasee and Mr. Saunders. Well, as the attorney for the defendant, Taylor Denise Schabusiness, I'd like to share with you that I believe this case is a puzzling, unclear, confusing, and bizarre set of facts. It is unknown what really happened between February 22nd of 2022 and February 23rd of 2022. What we do know in this case is that numerous law enforcement officers testified. We had detectives, we had police officers, we had Dr. Trunkita, and DNA experts, forensic specialists, lots of different people, some citizen witnesses. I'd ask that you consider setting aside your emotions and decide this case based on the facts that are presented, that have been presented. You've sat here for the last 3 days. You've been here in court. I know that you've listened very closely, but don't assume anything. When you deliberate about all of the facts. What we do know is that law enforcement officers on February 23rd of 2022 went to 829 Stony Brook Lane in Green Bay, this small Cape Cod home, and made contact with the occupants, Tara Pakinich, Stephen Hendricks, and Ava Wheelock was woken up, but they were all sitting at the kitchen table, and officers came in to see what was going on. There was a concern, obviously, that there was a bucket down at the end of the stairs. And we heard from Detective Roth that this was an ongoing investigation, law enforcement. They were trying to piece this together. It was an unusual situation, and so they were trying to find out what happened. Unfortunately, I believe it was Officer Plonky and Officer Wanish, they testified, they came here and indicated that they went down to check out what was in the basement, and there was it was the head of Shadtherian in that black Fleet Farm bucket. And the investigation continued on. But what I submit to you, ladies and gentlemen, is that there really are no eyewitnesses as to what really happened down in the basement. There is no Taylor Schabusiness there, no other people there, and so that'll be something that you'll have to consider and think about. Then law enforcement realized that there was a secondary scene, and that was at 2353 Eastman Avenue, apartment 1 in that parking lot. And you saw the video. The officers, I think it was Officer Garth Russell, and a couple of other ones, they walked up. Microphone. Sorry. Thank you. The officers walked up, and they parked a distance away, and they walked up in the snow, and they saw a line of cars in front of the apartment complex. And they saw that, a minivan. It was a gold Town and Country Chrysler minivan, and that was a vehicle of concern. Had some snow on the back windshield. There were vehicles on either side. And the officers walked up, and they they saw some lights on the van, and then they saw someone come out the front door, and it was my client. It was Taylor Schabusiness. At that point, she was arrested by Officer Russell, and another officer then realized there was a male inside of the apartment number 1 down the hall. Ended up being Scott Tomes, and he was told to lay on the ground and held at gunpoint, and then he was arrested. So 2 people were taken from the apartment building and taken down to the police station. There was a search of the Eastman Avenue apartment. We don't have any body parts there. I would submit that there really wasn't anything of evidentiary value there. And that was that. Later on, officers and detectives realized that that minivan was something that they were concerned about, so that was taken down to the police storage garage. And then we found out that from Dr. Tranquita and some of the other forensic specialists, Andre, I believe it was investigator Andre, and Zarnecki. And so they donned Tyvek gear, protective PPE equipment, and they methodically investigated the back of the minivan, and they found the crock pot box that was in a laundry basket sitting on a seat, and there were human remains in there. Nobody saw Taylor Schabusiness driving this minivan. So these are some of the facts that you got to think about. Don't rush to judgment, but talk about it, analyze it. As jurors, you have to analyze the facts that you hear, and you have to apply the law that the judge gives you. It's a daunting task. So then we hear, you saw the video, the interview between Detective Groff and my client, Taylor Schabusiness. She was taken down to the Green Bay Police Department. Photographs were taken of her, and clothes were taken, and she was put in a yellow suit and then later a blue suit, but she was asked questions. And you got to remember what she said and what questions were being asked. She did say during the interview, "I can't think right now. I'm effing nuts." She said that she was up all night, that the body would rebuild itself. She said weird, odd things. Consider her credibility. Consider what she says. Consider what she said to Detective Groff or Detective Scanlon. She said stuff, I would submit, that she said things that didn't make sense. She says, I have no idea to some of the questions that the detectives asked her. You remember seeing the video on the screen. I'd ask that you recall that she had inappropriate laughs, inappropriate smiling, odd responses. I would submit that she indicated that she did not have sex. She did not have penis to vagina intercourse with Schabusiness. She indicated that she came to the residence and they went downstairs, and within 5 minutes they got to it, whatever that means. She talked about, during the interview with Detective Groff, rebuilding muscle or rebuilding into muscle. Sometimes she wasn't responsive. She talked about hearing gunshots, but I believe Detective Groff said that there were no gunshots in the area of Stony Brook. Eastman Avenue was some other place. She said she was paranoid. She said weird things like, I don't like open spaces. I don't like open spaces. No clothes came off, no kissing. She said that she allegedly put the dildo into Mr. Therian's backside, his butt area, his anal area. There's no DNA. We heard from Kevin Scott, DNA expert. He must have done real well in school, in chemistry and all that. But the swab from the dildo, item J1, it says the possible contribution of DNA from Schabusiness is inconclusive due to the complexity of the mixture. I would argue that his DNA is not on the dildo. So I would argue that even though the state is charging out third-degree sexual assault, there is no shred of evidence to support that particular charge. And I'd ask that you take that into account. No evidence at the Eastman Avenue apartment. When Detective Groff had my client come down to the Green Bay Police Department with Detective Kevin Kempf, they were talking with her for a while. The interview was maybe 3 hours or so. And then they took a break because Ms. Schabusiness had cuts on her thumb, scratches on her palms, other cuts on her fingers. Some of them were deep. You saw the pictures because I believe they were published. And she was taken over to St. Vincent's Hospital for medical evaluation. I would submit that the blood on her hands may have been her own because of the deep cuts that she had suffered, or that she had. The defense had subpoenaed Mr. Scott Tomes. He was unavailable, and he gave an account of that night. And he had indicated, at least on Monday night, that would have been February 21st, that Taylor Schabusiness and her friend Shad came over. He had seen Shad before, but didn't know his name. And then he thought that they hooked up to do meth. And then he talked about his vehicle. And he talked about that Taylor Schabusiness had used his vehicle in the past and didn't get permission on that particular night. Then he indicated that he was drinking. And then he indicated that Taylor Schabusiness returned to his house around midnight with his vehicle, went to her bedroom, and he had a suspicion that she may have been high on drugs. And then he had indicated that Taylor had the bedroom and that he would sleep in his chair. So that's, something else that you have to think about. We heard from Lieutenant Buckman. He was a veteran on the Green Bay Police Department, and that he was doing some investigating, and he wasn't sure if Taylor Schabusiness was a suspect or a victim, because it was an ongoing new investigation. So that's something you have to take into account as well. The state brought up some photographs, a picture of Taylor with her phone. And young girls, I submit, they like their phones. So do all kids, young people. They like their phones, and they look up things on the internet for a variety of different reasons: shock value, curiosity. But we have a situation here where Taylor did do some searches about Jeffrey Dahmer. I would submit that that's a ruse, that doesn't necessarily mean anything, and that people search the internet for all kinds of things on the internet, and that it's for shock value. So that shouldn't really play any part in this case. I would ask that you discount that and set that aside. Now, I would argue that I would argue that it's not a clear case here. Was this an accidental death? Did Taylor Schabusiness kill Shad Therian? Was there intent to kill Shad Therian? Did Taylor Schabusiness have the mental purpose to kill Shad Therian? Different theories, different things for you to think about. You are all like analysts, and you have to assess and decipher the facts. The facts here are very complicated, confusing, unclear. 2 different locations, no eyewitnesses. Taylor Schabusiness, we learned that she went to school with Shad Therian, middle school, Bayport High School. They were friends. They hung out. You heard from A.J. Gannon. He hung out with them as well. Can you trust what someone says when they're hopped up on meth, on drugs? The state wants you to look into Taylor Schabusiness's mind to find out what her intent was. And that's a difficult task. Did she have a clear mind on February 22nd of 2022 as to what was really going on? Accidents can happen. When accidents happen, people can make other choices in a panic. Something for you to think about. This sexual assault charge, how can you have sexual intercourse with the facts that have been laid out and presented to you? It's mind-boggling. How can you have sex when genitals are in one place and body's in a different place? It's foggy, it's cloudy. It's hard to imagine, almost impossible to try and figure out what did or didn't happen. I would submit to you that no sexual assault occurred. I'd ask that you find her not guilty of third-degree sexual assault. You can't rely on everything Taylor Schabusiness says. Think about that, please. She chose not to testify under our Constitution of the United States of America. She doesn't have to testify. That's what the law provides. You don't have to take the witness stand. You have a right to remain silent, and you can't use that fact alone against her. I would argue that based on all of the evidence and the testimony in this case, that you find my client not guilty of all the charges. Thank you very much for your time.
This case is puzzling. This case is bizarre. This case is in absolutely no way unclear. It is crystal clear what happened to Shatherian, and we know that. We know that because the defendant told you. She told you what she did to Shatherian. Is it bizarre? Is it unnatural? Is it strange? Yes, absolutely. People do bizarre, unnatural, strange things. They engage in criminal conduct. People kill other people and they dismember them. That's what Taylor Schabusiness did. And we know exactly what she did because the words from her mouth told you with specificity what she did. Can we trust always what Taylor Schabusiness says? No, but as Mr. Saunders told you, we trust but we verify. We didn't stop at taking her statement. We corroborated. She guided the investigation with the specificity of her statement. How can we not trust her statement when she describes in detail the mechanism of injury, which is exactly what is described and confirmed by Dr. Tranquita? Excessive strangulation over a period of time with layers of injury, exactly as she described it. Described that his tongue would be out. She described that. Dr. Tranquita described that and showed you that. She described his struggle. He's struggling for his life and she continues to pull that chain, demonstrating her intent to kill Shatherian. And we know that because we see that in the physical evidence. We see the marks on Shad's tongue. We see the damage to his neck. She described to you what she did with his body after she killed Shad. And we know that it's true because the body parts were exactly where she told you they were. Detectives are finding everything she says on scene, and you saw it with your own eyes, that just what she told you is exactly where those things were located in that residence. She wasn't cloudy. She wasn't unclear. She wasn't hopped up on drugs. She knew where to find the drugs. She knew where they'd find the pipe. She knew where they'd find the chains. She knew where they'd find the knives. She knew the name of the bag, where the body parts were going to be located. She could tell you that she put the organs in plastic bags. She could tell you that she cleaned up with Clorox wipes and she put them in the bags as well. She could tell you that his lower extremities were in the car. This is the most specific confession anyone could ask for, and it is corroborated in detail by the work of the Green Bay Police Department. This is bizarre, this is strange, this is unnatural, but it is in no way unclear. We know exactly what happened. We know exactly what Taylor intended to happen for all three of these offenses. She engaged in intentional conduct in each of these acts. You are asked to look at each of the 6 elements, and there are only the 6 elements that Attorney Saunders described to you. That as to count 1, she did cause Shad's death. There is no doubt she had the mental purpose to do that. And that she knew that her conduct was practically certain to cause it. She described to you how she visualized him struggling, blood coming out of his mouth, but she did not stop. He's turning purple, but she did not stop. He's coughing up blood. He's pissing himself, in her words, but she did not stop. This was a deliberate choice on her part to kill Shad Therian, and she knew that her actions were going to cause that. And in fact, she was asked whether or not she liked it, and she confirmed that she liked it. She was asked whether she was sexually aroused by killing him, and she said she was. Her mental purpose was clear. As to the mutilating the corpse, again, there's no doubt that she intentionally did that. She described the detail. She described her frustration as she's mutilating this corpse, and she described her purpose in doing so. How else am I going to get the body out of the house? How else am I going to get away with this if I don't cut this body up? And she didn't just cut it up and leave it there. She cut it up, she packaged it, she cleaned up after herself. Her purpose in dismembering Shad was clear. She wanted to attempt to get away with this crime. A crime that she intentionally committed, a crime that was not accidental, that was not a surprise to her, that she didn't wake up from this nightmare and then call the police and call Shad's mom. No, she made the second deliberate choice. After deliberately choosing to kill him, she deliberately chooses to dismember him and attempt to cover up her crimes. And likewise, the sexual assault is equally clear. There's no doubt that she had sexual intercourse, and for counsel to say that we can't merely accept the word of the defendant, you're asked routinely in sexual assault cases, juries are asked routinely to take the word of a crime victim with no physical evidence. We don't have to take the word of the crime victim. We have the word of the defendant who confesses to this crime and tells you exactly what she did, again with specificity, and tells you, you know what, I did this and I did it with that dildo, and here's where you can find the dildo. It's in the wall, it's in the box, I put it away. And what happened? They found it in the box, put away exactly where she described that it would be. And she clearly was sexually aroused by this whole incident, and she described that to you herself. So clearly it follows, it makes sense, it's logical, it is reasonable that she did exactly what she told you she did. There is absolutely no reasonable hypothesis consistent with her innocence. The only hypothesis, the only choice that you have before you here today is to find Taylor Schabusiness guilty of each and every count for which she is charged. All of those elements have been proven beyond a reasonable doubt, and I ask that you return a verdict of guilty. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Taylor Schabusiness. 1 reading, we the jury find the defendant, Taylor Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of third-degree sexual assault as charged in count 3 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in 1 count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have a question, the court will talk with the attorneys before answering it, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with this verdict. Now, ladies and gentlemen, this is the unfortunate time, because now is the time when we select the alternate jurors. Let me tell you what the process is going to be. The computer has selected 4 of you. We're going to read those names here shortly. If your name is read, I'm going to ask that you simply stand up and go have a seat in that first pew right there, because I'm going to want to address you, first pew right here, because it's open. And I'm going to address you after the other jurors have been excused. The remaining 12 jurors are going to participate in the deliberation process, and you will accompany the bailiffs to the jury room. If you're selected as an alternate, your participation in the case at this point will be concluded. I will make sure, however, that you are addressed by a bailiff who will assist you in retrieving any items that you may have in the jury room. So at this time then, I'm going to ask that the clerk read the names of the 4 jurors that have been selected by the computer randomly.
Nicholas Rozek. Sean. That you will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Thank you.
All rise for the jury. Might be seated. I want to first address Mr. Rozick, Mr. Lynette, Mr. Beerhalls, and Ms. Schrader. I want to thank you very much for your service on this case. You've all paid careful attention. I've been able to observe all of you throughout the trial, and I really appreciate that, and so do all the parties. At this time, your service in this case is completed. Many jurors ask if they're allowed to discuss the case with others at the conclusion of their service. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, the lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. Finally, should any of you have any questions before you leave today, please let the bailiff know before you leave. And you can confer with me at any time before answering any questions asked by anyone if you choose. The bailiff is standing right back there. I'm just going to ask you to get up then and accompany her out that door, and if there's anything that you need to retrieve. But again, thank you for your service. Anything to take up before we recess? Mr. Saunders?
No.
Mr. Froelich?
Not at this time.
Very good. Then we are in recess. I'd ask the parties to remain very close here to the courtroom for at least 30 minutes. Oftentimes, if questions come in, they come in early. After that, if you just simply leave a cell phone number where we can reach you, then you're free to depart, but I'd still ask you to remain close to the courthouse. But at this time, then, we are in recess.
Thank you.